6th April order. 6th April order.
My lords, would like to see from page 7, my lords. Progress of investigation.
Which part you want us to read?
Page 7, your lordships will see what is the update, my lords. We have pointed out, my lords, what is the investigation we have carried out. Site inspection, etc. Witness examination is at page 9. Digital evidence we have collected, my lords, para 21, 22. Technical analysis is going on, and the further arrests that are made are at para 28. And your lordships will see the conclusion in para 30, my lords.
Keep it.
So, my lords, we'll continue our investigation, my lords.
I think one is para 25.
Yes, my lords.
Very important, the very opening line.
Yes, my lords.
Not the, just wanted to add, not that whatever cooperation they wanted, the Home Secretary was written to, we've given it. And they've asked for some additional material, which we have, again, which letter came yesterday, whatever they want, additional security.
My lords, that was also there in our status report. We have received cooperation from the state, my lords.
In the next phase of investigation,
Yes, my lords.
we would like some of the persons illustratively you have identified in para 28.
Yes, my lords.
Like to specifically know,
Yes, my lords.
is there any political background of these people?
Yes, my lords. In fact, the third person is the key conspirator. He's only been arrested yesterday, my lords. So we'll, my lords, present the IG NIA is here, my lords. She has signed the status report.
We don't want to leave this matter like an academic exercise.
Bow down, my lords.
We'll take it to some logical conclusion.
Please, my lords.
Not one, just one thing, in terms of your lordship's order, oral observation, the Home Secretary, the DGP, and earlier the Chief Secretary have all met and paid their regards, not met the Honorable Chief Justice of the High Court.
No, that they have filed their affidavits also regarding.
Yes, but that's an oral observation. We had to comply with it. We've done the needful.
There is nothing. We don't carry grudge against individuals or anything. We only
Yes, of
sensitize them, and now Chief Secretary says that he has taken up the matters, the additional security has been provided. But we have received one communication from the Chief Justice of the High Court today in the morning, and this we would like to read out completely because it deals with both issues. Where he has said, under the direction and supervision of the Honorable Bench presided by Your Lordship, we started the SIR exercise in the state of West Bengal in last week of February 26. The Judicial Office of the state, with the assistance of Judicial Office of Jharkhand and Odisha, have completed the Herculean task of deciding more than 60 lakh objections in the SIR process in the first week of April 2026. The exact number of disposal are depicted in the following chart. Now, total objections were 60,06,675. They have decided 60,04,885. What is left for technical reasons, they say, are about 2,000, that is 1,823, which is 0.03% only. And e-signature also, almost 60 lakhs were over, maybe that left remaining also. That, Mr. Naidu, you might be knowing. But anyway, then the Honorable Chief Justice pointed out that in terms of order of 6th April 26, he constituted a committee of 3 former Chief Justices or judges to establish the procedure that will be consistently followed by 19 appellate tribunals without any delay, and to endeavor to have the procedure prescribed by 7th April 26 to accelerate the resolution of the appeal. In the late evening of 6th April 26, a committee was constituted, presided by former Chief Justice T.S. Yugananand. Then he has pointed out the honorable judges of the committee prepared a standing operation procedure SOP to be followed by all 19 appellate tribunals on 7th April 26 as mandated by our order. Then based on 10th April 26, a team of the High Court made an inspection of the venue as regard the preparations to house the appellate tribunals. The team reported some minor deficiencies were there. Since it appeared to be ready to be functional, on Sunday, yesterday, the 12th April 26, a portal introduction session and interaction was organized in the presence of Chief Justice Committee members, both the former Chief Justice of the High Court at Calcutta, who are now members of the Appellate Tribunal, and other former judges of the Appellate Tribunal. The same was followed by a working lunch. 17 honorable judges joined the session. They were introduced to their team members. They took first-hand experience of handling the appellate portal. Thereafter, in the interaction, the honorable judges of the Appellate Tribunal have discussed about the modus operandi to be followed and decided to start functioning from today. That is, today morning they have started. Now, 2 areas. One is security cover requires to be provided to the judicial officers of the state who were engaged in the SIR exercise. So we will simply direct that this security arrangement will continue till
Yes,
further order, at least till all the elections are over in West Bengal. We would like our officers to be protected.
True.
As per the feedback from the Election Commission of India, 34,35,174 appeals have already been filed. The disposal of appeal will obviously will consume some time.
Well, just request the figure to be repeated. That
Before we come to the hearing, just write down. We have received a memo dated 13th April, a DO letter dated 13th April.
please, এটা দাও তো, তিনটে দাও, দুটো দাও।
The DO letter dated 13th April 2026 from Honorable Chief Justice of High Court at Calcutta. It is imperially pointed out that in compliance to the orders passed by this court, the SIR exercise in the state of West Bengal was commenced in first week of February 2026 by the judicial officers of the state, with the assistance of judicial officers of Jharkhand and Odisha. The Herculean task of deciding more than 60 lakh objections in the SIR process has been completed in the first week of April 2026. To be precise, Honorable Chief Justice has pointed out that 50,06,675 objections were required to be verified, out of which 60,04,852 have since been verified. Only 1,823 are left, are pending due to technical reasons. Similarly, the exercise of e-signature has also been to the extent of 99.69% has been completed. That's paragraph. And the Chief Justice has further pointed out that in reference to our subsequent order dated 6th April 2026, a committee of 3 former Chief Justices stroke judges was constituted to establish the procedure to be consistently followed by all 19 appellate tribunals which have been constituted to decide appeals against the orders passed by the judicial officer while deciding objections. It further explains that the 3-member committee has prepared a standing operation procedure SOP which will be followed by all the 19 appellate tribunals. The letter informed that yesterday, that is 12th April 2026, a portal introduction session and interaction was organized in the presence of Chief Justice, former committee members, and the former Chief Justice of the High Court, and other members of the appellate tribunal. The Honorable Chief Justices, or former Chief Justices, or judges who constitute the appellate tribunals were introduced the first and experience of handling the appellate portal, and they were apprised of the procedure to be uniformly followed so as to enable them to decide functioning from today, that is 13th April 2026. Next paragraph. We place on record our acknowledgement and appreciation for the nearly impossible task which Honorable Chief Justice of the High Court has come up with the able assistance of the judicial officers of State of West Bengal and the neighboring states have completed. The information given to us from time to time undoubtedly revealed that how difficult it was for the judicial officers to undertake the task for which they worked even on Saturday, Sunday, without taking any leave. Honorable Chief Justice also, without causing any, while performing his judicial duties in the normal course of continue to devote extra hours for the purpose of constant monitoring and ensuring that the assigned responsibility was completed smoothly. We equally appreciate the zeal and enthusiasm with which the judicial officers have also performed their duties. Next paragraph. We have no reason to doubt that the former Chief Justices of judges who have graciously agreed to be part of the appellate tribunals and to whom the first hand experience of handling the appellate portal has been introduced, will also be able to complete their task within a reasonable time. reasonable time, and all stakeholders will continue to extend their cooperation to them in this regard. Next paragraph. We the new letter sent by the Lord Chief Justice also highlight the areas of concern, first of which being the security cover required to be provided to the judicial officers of the state who were engaged in the SIR exercise. In this regard, is to direct the state government, to direct the Union of India as well as the state government to ensure that the direct the Election Commission of India as well as the state government to ensure that the security already provided to the judicial officers is not withdrawn and or assess further threat and perception to them and deploy for additional security if so required. It is made clear that the security cover given to the judicial officers shall not be withdrawn without prior permission of this court and in any case till the entire election process is over.
Let some have gone back to their states.
My lord, kindly, my lord,
The deployment of central forces in terms of our order directive, it was 1st or 2nd April.
Second.
Passed on 2nd April 2026 will consequently continue till further orders.
Let some of the judicial officers have gone back to their. Isn't it first April? Some of the judicial officers have gone back to their respective states. my lord.
Then you know, that's only because those who are working in West Bengal.
Only those who are working, Lord.
Lord, the deployment of the vulnerable areas may also
Lord,
continue. Let it be at the behest of and monitored by a monitoring committee, and the ECA may do it. Otherwise,
No,
my
no,
lord, the
this is-
postponed violence which was witnessed in 2021 could be repeated, and it is a deterrent, my lord, on a free and fair, peaceful elections even in 26.
That security will continue.
my lord, we have some
But
certain things.
Vulnerable areas as identified by the ECI, let them do it.
My lord, we
That
have
is a matter
certain
for
things
it.
to say.
Doctors could issue the
My lord, we
ECI
have
to do
certain
that.
things to say. My lord, here, this is, please, madam, please, kindly see, my lord. Say
That
to
you
your
can look
lordship
into your counter
that-
affidavit and then.
On this
Right.
issue, there
My lord, kindly, just, kindly,
is
kindly,
there any dispute on this?
my lord,
issue?
kindly bear with me.
Please
No,
listen
My
to
lord,
us
no
first.
dispute on these issues.
no,
No dispute.
Please listen us. On this issue, there can't be any that that's all we have said, only this much right now.
taken over by the Delhi police. we have no dispute.
So
Let them
whatever ECI or the state government, whatever.
All investigations also, normal investigations.
ECI
Election
cannot
Commission has
exercise its
directed,
powers under the
no,
Constitution.
no investigation would be made only by the Delhi police and the other polices of the different states. We don't have any objection.
Compliance to our.
Emerg-
In compliance to our order, it will. 2nd April and the previous order. 6th April 2026. The Chief Secretary State of West Bengal and Director General Police of State of West Bengal have also filed their respective compliance affidavits. It is stated by the Chief Secretary that a virtual meeting was called on 3rd April 2026, in which necessary directions were issued to the police authorities, to the police/civil administration to ensure security arrangements for judicial officers. It has been further stated that the security arrangements for the judicial officers have been enhanced by including additional CAPF personnel. Next paragraph. The Director General of Police has also in his affidavit explained that a comprehensive security plan has been prepared in all districts and police commissionerate for all districts and police commissionerate for the security of the judicial officers and necessary deployment and arrangements have been made. These arrangements include 1I, provision of PSOs, 2I, escort during transit, 3, security arrangements at place of work, and 4, enhancement of CAPF forces in sensitive districts. Next paragraph. In light of the directions issued in the earlier part of this order, among the recommendations of the Honorable Chief Justice of the High Court, we direct the Chief Secretary, Director General of Police, and other police and civil administration authorities to ensure that the security arrangements made for judicial officers, including the enhanced security given to them, is not withdrawn without prior permission of this court.
All pending criminal investigation all over West Bengal, whatever the nature of the case, and the Delhi police will investigate. This is the power of the Election Commission. Anyway, Miller, I am not on that, Miller. I am on the SIR. Kindly just hear me, Miller. I am only on the SIR.
2 minutes already, 4:15. I have.
Miller, kindly bear us.
just-
Miller, kindly bear. Please, Mr. Devan.
I-
Kindly see, Miller.
Let's
Your
join
lordships have been
issue on
given
that allegation.
given an
There's no truth.
impression
We
that
have not given any such
all
detail.
cases have been adjudicated. Miller, kindly see,
We have
all
not
your
given any
lordships
such
have
detail.
given the impression that all pending cases have been adjudicated. And if possible, kindly see the list. See, Miller.
What do you want us to see?
Miller, kindly see, 6th April, this voter list has been published in Raghunathganj, constituency part number 196. All are under adjudication. All are under adjudication.
Only 1,820.
No, it was said before your lordships on the super first phase is concerned, everything was over. This is the first phase. This is the first phase. Now, Miller, kindly see this. And this is the one case I have, it has come within my own knowledge. Kindly see.
What do you want to show us?
May-
Miller, the
Maybe
under
lordships
adjudication
applicable.
case is still pending. That's why I am saying.
1,000.
Miller, that is the second part, first part. On the other day, it has been said before your lordships by the Election Commission Council.
The
that-
total, how many total objections were came together?
Miller, this is going to be,
Mr. Bandyopadhyay, if the judicial officers have completed their
Yes.
adjudication in the first instance in respect of any assembly constituencies by 9th of April, even if they have exceeded by 1 or 2 days in respect of the 153 assembly constituencies, we have given direction
Miller, kindly
that
see.
they
There are two dates are there. My lord, kindly see, 2 dates are there. One is 6th April, and my lord, kindly.
Sir, the elaboration you will make, we are giving you the answer. The 153 constituencies whose last date of nomination was 6th of April, the list was published on the night of 6th of April.
Right.
There was some spillover on 7th or 8th. Those names will be included in the electoral roll for the 23rd April elections.
6th April, sir.
It's not
My
only,
lord.
addition
This
to
is
that.
all
even
under
after the-
adjudication. All under adjudication, it has not yet been adjudicated.
May I beg you?
Well,
lordship,
that
on
is
that, yes.
Adjudication.
That is, has not been brought out.
Don't worry, if their names are there, they will
Yes.
be voting.
Yes,
another
even after
submission,
the
sir.
appellate
Kind-
adjudication, they
kindly
will have
hear,
right to
my lord,
vote.
the-
Cleared
Kindly
by
ensure
6th
that.
May.
My lord, another submissions. My lord, 16 lakhs appeals have been filed. 16 lakhs Milord, if this is, it is not possible to dispose of 16 lakhs appeal.
That-
Kindly allow Milord to franchise their vote.
Where is the question of voting them?
Milord, 16 lakhs are
Then
pending.
those who have been allowed, then we should stay that also then.
Milord, 16 lakhs
When
are,
orders are passed,
Milord,
whatever you are
10
happy.
kindly see, 10th March, your lordship was pleased to constitute the tribunal.
We will
16,
consider this.
Milord, 10th March, your
Milord,
lordship.
Bandyopadhyay, it
One
cannot-
humble,
In block,
How
16
can it
lakh
be?
appeal will be allowed. The number is at variance. The Chief Justice's report to us is 34 lakhs.
34 lakh appeals.
34
I couldn't
lakh
hear that. I
appeals.
just wanted to know.
34 lakh, Mr.
34 lakh, 35,174.
34 lakh, 35,174.
As on 11th April 2026. By now it's
Now-
my turn.
Now, we will try to create a via media as much as responsive to the twin requirements. of
yes.
A first layer adjudication in one hand and your aspirational right in the appeals that have
So,
been.
Manoj, may I just invite
But
attention?
only
Just-
the appeals which are allowed,
I'm
they will be
first of
allowed
all
to
very
go.
grateful
That
for
is the
this figure
clarification
because I
is.
didn't hear it when your lordship actually mentioned it. The figure of the total pending appeals, which your lordship says is more than 34 lakhs. So that would include. Now, I have just one point. May I just request your lordships to just consider section 21 of the Act? Could you?
Just read out.
Yeah.
21 proviso.
21(3), I just,
Mr.
and the proviso.
Proviso,
Yes.
but that we've crossed that bridge.
Manoj, I'm
We have crossed that
suggesting-
bridge.
Manoj, I'm suggesting that with the proviso read with the statutory appeal, your lordships have of course given us.
One problem is, please see.
Now,
Yeah.
Mr. Diwan,
More than-
see rule 24 of the registration of
Yes,
electoral
yes.
rule. An
Yes.
interim suspension of a decision cannot be done in appeal.
No, Manoj, keep the
In the
intent.
other aspect,
Yeah.
55% objections have been rejected.
Yes.
Those, they have been included.
Yeah.
The objectors have gone appeal against that. The
Yes, you are
34
right.
lakh.
That's how you
appeal-
get 34 lakhs.
Yes, they ask for the same order.
Correct.
No,
They will also ask for the same order.
Now, Milord,
We
therefore,
got back to the same position before appointment of the judicial officer.
Milord,
but
kindly,
the proviso,
kindly,
as your lordship correctly points out, perhaps the proviso pushes the proviso, Manoj, which is the statutory wisdom of the legislature, appears at least to us to revert the position prior to the SIR exercise. Please just consider that element. If that is the case, Manoj, I would make two suggestions. One is your lordships will consider how to balance these appeals, particularly having regard the proviso to 21(3). And the second respectful submission that I have is that surely, my lords, if the appellate tribunals, which have just started functioning, I think that was the, yeah, they've just
As per the-
initiated. If there is substantial progress, my lords, over the next week, then surely there ought to be, my lords, please keep in mind some,
That is what we are
There-
seeking to focus on.
yes, some supplementary, my lords, list which comes
Absolutely,
out.
that we are seeking to
because-
focus.
We are also equally conscious of this.
No, I'm very grateful. but
Millets,
that
when
is
it comes to
point-
section 21,
Correct.
it's an ongoing process. It goes on. When it comes to millets, freezing and finalization and the right to vote in that particular one millets, that's governed by section 23, read with the rules. Insofar as 21, nobody denies it should go on. That's what my lords have held. That the appeals, let them go on so that they'll have their rights vindicated if at all they could. And then
Mr. Naidu, we are conscious that pending of an appeal does not amount to suspension of the primary decision. Right, that is the rule under the rules. But if an appeal is disposed of, what would be its consequence is also in the rule, that is subsection 5, that the registration officer will immediately amend the electoral roll.
millets subject to, millets,
So there.
yes.
And there, Mr. Naidu, subject to our exercise of Article 142 powers.
Millets, yes, millets. When, as and when your lords take up millets, we'll submit our notes, we'll submit the decisions because it has at least half a
Can I
dozen
make
times
one
considered
request
by
to
your
your lordship?
lordships.
can I?
Not time that it is no longer recent agreement. Your lordships have considered, your lordship have laid down the law.
Milord, can I make one
Thank you.
request that
Everything.
first phase appeal,
Yes,
23rd April is the first election date.
Nowhere in an
All that
election-
appeals, Milord, pertaining to that, as far as possible, dispose it of by 20th
that's
or
why millets.
21st.
On the day
That
6 that's been
request-
finalized, they are
The
in.
way, Milord, the adjudication process you have,
Sorry.
your lordships have divided into two.
Kalyan, we are equally concerned about these issues.
Yes.
Let us thing, because we cannot create a situation where the appellate tribunal members are bogged down and they leave everything on, in the mid of it and create another challenge before us. Please appreciate that part also. So we have to,
Well,
similarly, as again we are pointing out, see the second side of the consequence. There is a writ petition today before us, filed, saying that wherever the objections have been rejected and we have gone in appeal, don't allow them to vote.
Yeah.
On the same analogy, they will also ask for it. So we have to think and
But-
draw a balance between.
my lord, at the end, just I say to your lordship, kindly do not, at the end, my lord, peoples of Bengal are not depending on anybody. They are looking towards your lordship, my lord. Deprivation is so much, only towards your lordship, my lord. Or only whether 142 or what, my lord, they want to exercise their right. These 34 lakhs peoples, they are not the genuine voter. You know, if they are not, if they are genuine voter, that is the reason 34 lakhs. They have gone there. Standing,
They are, my lord,
my lord, they are there to
just cover
looking
fire.
towards you,
Just cover fire.
Issue is,
towards you, not towards election
Everyone knows
commission,
how the
not
demography
towards
has been changed
anybody.
to Bengal. Everyone knows how the demography has been changed.
Don't say about Bengal.
Yes.
Yes, Bengal.
and Bengal
Don't
both.
say about Bengal. Bengal knows how to fight.
Both the demography
Bengal
have been
knows how to fight.
IC can't be
And-
Allow us to think and
My lord,
Don't blame.
would you list this on Friday or Monday?
this is just to
My lord,
cover
kindly-
fire, my lord, just to
My lord,
protect the
kindly keep it on
infiltrators.
Friday or Monday.
Yes, my lord. My lord, my IA is there. We are 106 people. My lord, my appeals are pending, my lord.
that doesn't bother us.
Yes, my lord, my appeals are
Pass it.
pending.
We have considered this aspect. We
Yes,
know that what's be coming from your side. We know what is their problem
please-
also. We will pass some order.
My lord,
That-
second, one other
My
aspect.
lord, kindly
My lord,
Lord,
please
one other-
consider my IA, my lord.
keep it on Monday or Friday, my lord.
My lord, one
My lord-
other aspect, my lord.
No Friday, now we.
My lord, one other
My lord,
aspect
before
regarding
23rd.
of these
My lord,
aspect
before
tribunal.
23rd, before
My lord,
23rd.
My lord,
One
please-
day before 23rd, please.
Thank you very much. Thank you.
Very significant hearing, I would say, that happened in Supreme Court today. Those who have joined this broadcast, they're all probably as anxious as we are and the people of Bengal as what happens to those whose names have been deleted and who are now looking for redressal before the tribunal through the process of application. There is one confirmation that we have, and that is over 34,35,174 applications have reached the tribunal. Now, they could be physical applications, they could also be applications which have been filed online. So please understand, there had been about 58 lakh deletions which have happened through the draft list. Thereafter, another close to 7 lakh deletions which have happened through Form 7 and other methods. Totaling roughly about 64 lakh people have been deleted in round one. Thereafter, 60 lakh plus people had been put under logical discrepancy adjudication, matters which eventually reached the judicial officers for adjudication, out of which about 27 lakh people, more than 27 lakh people have been deleted. Now, who are these 27 lakh people who have been deleted? Many people are saying that they are those who have valid passport, valid voter ID, valid other documents, yet they have been deleted. Could be because of technical reasons, could be because of some other malified intentions, or could be because of a malware. Nonetheless, they cannot be deprived of or denied their fundamental right to cast their vote. If they are valid voters, valid citizens, then they should be allowed to cast their vote. Let's not discount the fact that Election Commission of India time and again has maintained that in this election, in Bengal election or in any election in India, a valid Indian should be given a chance to cast their vote, which means those who have the voting right, they are valid Indians, which equally means, as an opposite aspect, those who are now being denied to cast their vote or whose voting rights are now being wrested, their citizenship should also be considered under scanner, because if they are not Indians, then they are not Indian voters. If they are not Indian voters, which is equally, they are not Indians, right? So in that case, several people have come to fore and filed applications suggesting the hearing process could have been flawed, suggesting that the judicial officers could not have processed proper jurisprudence with the available documents, and those available documents had been selective as per the discretion of the micro observers and Election Commission of India. So yes, there have been a lot of controversies emanating out of this entire Election Commission of India's SIR exercise, which is now sub judice, which has now reached the Supreme Court of India. The whole matter has been discussed today as what happens to those who have filed their application before the judicial officers seeking review of Election Commission's decision to have been deleted them from the voter list. Now over there, the larger question is, if there are 34 lakh applications and those applications have to be disposed of, if those applications have to be disposed of by the former judges, including former chief justices who are part of the tribunal, and there are 19 such tribunals operating, how can they do it within another 2 weeks? Please understand, today is 13th of April and first phase of Bengal election is happening on 23rd of April, which is exactly in 10 days time. Bengal goes to polling. The first phase is happening on 23rd of April, in which 152 constituencies will be going for polling. And those 152 constituencies also include places like Murshidabad and Malda, and also East Bardhaman, places which have seen maximum deletions. Murshidabad has seen roughly about 4.5 lakh deletions, followed by Malda, which is close to 2.7 lakh deletions. Equally, there had been deletions in other districts like East Bardhaman. Equally, there had been deletions in districts like Birbhum. So yes, these people who have been deleted, they are part of those constituencies which essentially would be going for polling on 23rd of April. So you have a 10-day window period. Now the Supreme Court, from day one, ever since this idea of tribunal was conceptualized, and eventually it was decided that now the matters would be going to tribunal, the Supreme Court had made it very clear that neither on judicial officers who were adjudicating the logical discrepancy cases, nor the tribunal can be put under pressure, because these are former judges. The tribunal, the judicial officers were active judges who had let gone their active cases which are still pending across various courts in Bengal. There are judges who have been brought from neighboring Orissa and Jharkhand. So these judges have let gone cases which were pending before them, in a way, putting a big backlog in the judiciary's case data. Yet they have tried resolving this dispute, which has now become the center point of a massive political showdown between political parties, primarily Tribunal, Congress and BJP. Because BJP had been supporting Election Commission's SIR, and Tribunal Congress had been saying that BJP is trying to benefit out of these deletions, and the Election Commission of India had selectively deleted people in order to help BJP by manipulating voter lists. It is not a secret anymore. The kind of stories you have done, the kind of stories you have come across, people with legitimate passport have been suddenly disenfranchised. People whose other family members are legit voters, they have been disenfranchised. Imagine, in one house with 10 family members, 5 have been restored as voters and 5 have been deleted. So in one house with same credentials, like the same address, same 2002 voter list that every member had used for voter mapping, 5 have been approved the voting right and 5 have been denied. So obviously a lot of questions have come before the Election Commission of India, and the neutrality that the Election Commission of India has possibly followed in disposing of these matters. For example, the first decision was that they would be following the 2002 voter data list to do mapping of Bengal voters, and suddenly, after the draft list, logical discrepancy was born, and because of logical discrepancy, 60 lakh people had been put under adjudication. So obviously there had been a lot of questions before the Election Commission of India. The central question before the Supreme Court today, at least in the past 2 hearings, had been that it is because of the Supreme Court's intervention that judicial officers had intervened and taken up the job of the micro observers. And thus, out of 60 lakh people, roughly about 34 lakh people have gone back to the final voter list, while 27 lakh plus voters have now been deleted. Now, the tribunal is essentially for those 27 lakh people. What happens to those 27 lakh people? They are challenging the order of the Election Commission of India. And imagine if they are valid voters, they seek redressal before the tribunal. The tribunal finally decides that they are valid voters. But is it acceptable that they will not be allowed to cast their vote in Bengal election 2026 because there is a time constraint? Because the voter list has already been frozen for the first phase, that is April 23rd, and second phase, that is April 29th. And that was the central point before the Supreme Court today. That while those who have gone back to the voter list, those whose cases have been cleared by the judicial officers, will they be allowed to cast their votes? The Supreme Court today has verbally observed that yes, if those matters have been disposed of before 6th of April, then most definitely they should be going back to the final voter list, right? So if that is case number 1, what happens to those 27 lakh people who have been deleted? Will they be denied the right to cast their vote even if they are valid passport holders, even if they are valid citizens? To which the Supreme Court of India today, hear me carefully, has not closed the idea, and that is the moot point. The 27 lakh plus odd cases which are now there before the tribunal, and the Supreme Court says there are 34,35,174 applications before the tribunal. How many of them will be disposed of? No one knows. But will those getting disposed of, and if anyone out of them, even if one, is decided upon to be a valid voter, will that person be allowed to cast their vote in Bengal election 2026? To which the Supreme Court of India has not said a no today. Because Justice Joy Mallo Bagchi categorically stated that yes, that is the aspect we are trying to focus on. Categorically stated that that is the aspect that Supreme Court is trying to focus on, right? As what happens to those who have sought redressal before the tribunal, and if they get redressal, and if they're termed as a valid voter, will they be allowed to cast their vote in Bengal election 2026? To which the Supreme Court said, yes, we are seeking to focus on that. If the Supreme Court had said, no, they will not be allowed to cast their vote, the matter would have ended then and there. But the Supreme Court is trying to be considerate. The Supreme Court is trying to be considerate. And I would also want to draw your attention to one of the observations which has been made by Justice Joy Mallo Bagchi earlier today. That was pertaining to a different writ petition that had gone before the bench of Chief Justice of India, Surikant, and Justice Joy Mallo Bagchi, where somebody has said that what about my voting right? Why shouldn't I be given the right to vote? If I'm a valid voter and passport holder, I should be given some concession. And if I'm a mapped person, I should be given some concession. While the writ petition demanded extension of freezing of the voter list. And that particular writ petition has has been dismissed of because the Supreme Court is saying that they cannot interfere there. The elections are really round the corner. But having said that, today, the Supreme Court has made it very, very clear that while we are not extending the freezing of the voter list is already frozen for phase 1 and phase 2, but the Supreme Court has made it very clear today that they are not close to the idea of bringing back valid voters if they finally successfully sail through the test of the tribunal. That's the crux of the matter. That is the crux of the matter. I would say it is extremely important an observation. I would also try and play the statement of Justice Joymallo Bagchi, which he observed earlier today, where Justice Joymallo Bagchi earlier today in a different hearing had said that for a person born in a country, right to vote is simply not constitutional. It is also sentimental. Here, Justice Joymallo Bagchi, that's exactly what you have been trying to harp, that right to vote is simply not a constitutional right. It is also a very, very sentimental right. If I'm born in this country, if I'm a tax-paying citizen of this country, if I'm a passport holder, if I am a valid citizen of this country, no one can take away the right to vote, my right to vote. And that is enshrined in our Constitution. That is enshrined in our People's Representation Act. That is also enshrined in several sections of the Citizenship Act. That if you are a citizen of this country, you have a right to vote. An Election Commission of India, through logical discrepancies, cannot deny somebody this very right to vote if that person is a valid citizen. Can Election Commission of India decide a passport holding person of India is not an Indian and a Rohingya? Can Election Commission of India call somebody who is holding a valid passport an infiltrator, a Ghuspetia? Can Election Commission of India thus deny a person who is a valid citizen of this country the right to vote? Because mind it, today too, the Election Commission of India tried vociferously objecting to the idea that these people can be brought back to the voter list, no matter if that is a night before the elections, because that's exactly what is being demanded. That you have found discrepancy out of nothing, logical discrepancy you have found in illogical questions, fair enough. And people have gone back and stood in queues to prove that they are valid voters. Election Commission of India's job is to ensure elections happen in a free and a fair manner. Election Commission of India's job is not to ensure people's right to cast their vote. Because Election Commission of India in the past two hearings have tried vociferously objecting that no, let them not come back to this voter list of Bengal election 2026. Let them not cast their vote in this election. If they are valid voters, they will come back to the voter list in the future for future elections. Question is, what problem do they have in ensuring that they get to cast their votes in 2026 Bengal election if they are a valid voter, if they are a valid citizen of this country? And that aspect has been highlighted time and again today. That it is not about the Election Commission's whims and fancies. Election Commission of India initially resisted the idea of judicial officers coming into the picture, right? Judicial officers came and took over what micro observers were essentially doing. Taking documents, scrutinizing documents, assessing them, and then rejecting them. That's exactly what micro observers have been doing. A job of the ERO was allegedly done by the micro observers. The reason why it was contested before the Supreme Court at the first place. Then who are these micro observers? Where have they been borrowed and brought into the picture? They don't fit into the scheme of things. Election Commission of India did not do it during Bihar election 2025, and surprisingly, and to surprise you, that too was questioned today by Justice Joymallo Bagchi. Justice Joymallo Bagchi in a previous hearing earlier today had questioned Election Commission of India that please tell us, did you do the same thing in Bihar election 2025? Where SIR process had started first? In Bihar election 2025, there was no logical discrepancy. But for Bengal election 2026, Election Commission of India has found logic and merit in logical discrepancy. And Justice Jaimala Bagchi, in a verbal observation, has directly questioned the Election Commission of India that during Bihar SIR, the only thing that you have followed was mapping of voters, right? Mapping of voters. If your name is there in 2003, for Bihar it was 2003. So if your name was there in 2003 voter database, then you are safe. Yet there had been multiple controversies. Dog's name, cat's name, all those things came up in the draft list. Nonetheless, people who were dead, they were deleted. Dead people were brought alive. Dead people were brought alive in Bihar database. And people who were alive shown dead. So those controversies are separate. But at least in Bihar SIR 2025, the only procedure that Election Commission of India followed was your mapping with 2003 database, because that was the benchmark for Bihar SIR. Similarly, for Bengal, the benchmark was 2002 voter database. Now imagine 58 lakh names were deleted from the draft list. And what did the Election Commission say? That they have been deleted, either they have been absent, either they have shifted, either they are dead. For these multiple reasons, they have been removed from the draft list. Fair point? Fair point? Uske baad, Election Commission of India decided that there will be logical discrepancies in names mismatch, in somebody's surname coming ahead of the first name, because that was completely controlled by the AI software. So if my name is Mohammad Sheikh, and if my voter card read as Mohammad Sheikh, and if the Aadhaar card read as Sheikh Mohammed, that was seen as a major dispute. Fair point. Thus, people stood in queues to prove that these discrepancies may look different, but then there is no logic behind it. There are documents supporting that it is the same individual with the same name, and it's just the arrangement of the name had been identified by an AI tool, eventually prompting Election Commission to put them under adjudication. People went through that rigor, and uske baad, about 60 lakh people were put under adjudication. It's only when the judicial officers intervened and took matters in their case, took matters in their hands and followed every case one after the other, they have disposed of 60 lakh plus cases, which is commendable, out of which 55% people have been ratified as valid voters. Imagine, Murshidabad Congress candidate, he was deleted even after adjudication. The tribunal reversed the decision. Who deleted? Election Commission of India. Who reversed? The tribunal. So the scope of tribunal reversing decisions taken by Election Commission of India is very legitimate an expectation. Yes or no? If Murshidabad Congress candidate's name can be brought back to the voting data, a decision taken by the tribunal reversing the decision of Election Commission of India. Election Commission of India deleted him as a voter. If you're not a voter, you cannot contest election. He challenged that decision before the tribunal, and the tribunal reversed that decision of Election Commission of India, which means Election Commission of India can be wrong. So if Election Commission of India can be wrong in case 1, there is also a probability of Election Commission of India being wrong in 100 other cases. So if Election Commission of India is wrong, then Election Commission of India should be reprimanded, not people. Here it's a complete contrast. Election Commission of India is saying there is a scope of making errors. And for their errors, who would be paying the penance? The people, by not casting their votes. Because Election Commission of India, through their advocate, Senior Advocate Naidu, had time and again suggested that they don't want these people to cast their votes in Bengal election 2026. If they're valid voters, let them come back to the voter list in the future and for future election. And there is the larger objection. If I am a valid Indian, it is my constitutional right to cast my vote, to have that ink on my finger. An Election Commission of India's decision cannot deprive me of my constitutional right. Let's hear in what Justice Joy Malabakshi had said today in the morning in a course of another hearing, where he clearly suggested that, you know what, if you're born in a country and if you know you're born in this country, then right to vote is simply not constitutional. It is also sentimental. Please listen in.
Yes, Millet. Could my lords?
Going through 1,000 documents a day, if our correction or accurate rate is 70%, at least speaking for myself, I will rate the activity excellent.
Excellent.
So this is the pressure at which the judicial officers have worked. And so there will always be a margin of error. And in these situations, again, tested from the principles of reasonableness, due process, we need to have a robust appellate.
Yes, Millet.
We need to have a robust appellate program where both parties
May I add only one thing,
can
Millet?
steal it and have a continuing right.
Yes.
Somewhere we are getting blinded by the dust and fury of an impending election. But a
Well, it's-
right to remain on a roll, a right to vote in the country where you are born. Yes. Is something which is not only constitutional, it's sentimental.
Indeed, Millet.
It is the biggest expression of nationality and patriotism that you are in a participatory process.
Democracy.
to create and elect a democratic government. So this is something which we need to very seriously.
Precisely, Millet. Precisely. Involving all states that have been subject to SIR.
Please help.
The exclusion or inclusion, we have given the percentage. West Bengal doesn't stand out in any manner. It's been on a par with many other states. And only question is that, my lords, with regard to manpower, my lords have come to our rescue.
We are not bothered about West Bengal standing out or West Bengal.
It's been on a par, my lords. Only question is,
being a common theme.
yes, yes, my lords.
But today, logical discrepancy has not been a category in others. We have examined Bihar and we have found not a single person was flagged on logical.
Millets. We have given statistics, Millets, involving all states that have been subject to SIR.
Please help.
The exclusion or inclusion, we have given the percentage. West Bengal doesn't stand out in any manner. It's been on a par with many other states. And only question is that, my lords, with regard to manpower, my lords have come to our rescue.
We are not bothered about West Bengal standing out or West Bengal.
It's been on a par, my lords. Only question is,
being a common theme.
yes, yes, my lords.
But today, logical discrepancy has not been a category in others. We have examined Bihar and we have found not a single person was flagged on logical.
Millets.
Very interestingly, there was another, another very significant discussion which happened inside the court today, and that is proviso to section. Now, what is this proviso section 21 subsection? I just want to quickly read a small portion from Indian Qanun. Here it says, if any question as whether to a person is or is not a burglary arises in the course of any suit, case, appeal or other proceedings before any civil or criminal court, the court shall refer it to the officer or authority mentioned in the subsection 1 of section 18 for decision, and such court shall dispose of the suit, case, appeal or other proceedings in accordance with the decision communicated to it by the officer or authority mentioned in the subsection. What is this? It is basically the tribunal. In very simple layman's term, it is the tribunal. The tribunal is a quasi-court which is now formed by the Calcutta High Court Chief Justice, comprising of 19 judges, former judges, including former Chief Justices. Now, these 19 quasi courts will now be deciding fate of more than 34 lakh applications. Now, please understand, 27 lakh plus people have been deleted from the final voter list out of the 60 lakh people who were put under adjudication, right? But here, before the tribunal, what's the number of application? The number of application is 34 lakh 35,174, which is almost 7 lakh more than the number of people who have been deleted after adjudication out of those 60 lakh who were put under scandal. Where did these 7 lakh people come from? So probably these 7 lakh applications could be of those who have been deleted from the first draft list also. We can't really confirm. But here is a situation where all the applications, discrepancies, now moving into tribunal, which would entertain physical hearing, which would entertain physical appearance. In this tribunal hearing, more than 34 lakh applications have already reached as per April 11th. Now, do you think 34 lakh cases can be disposed of by 19 tribunals, and that too within 2 weeks period? The answer obviously seems negative. But if they manage to clear out even one case, what happens to those people? If they're cleared by the tribunal, ratified as a valid voter, will that person be brought back to the voter list of Bengal because the voter list has already been frozen? So for that, the Election Commission of India today is saying that Section 21, subsection 3 Proviso Act is an ongoing process. It can continue, and it can continue for several days and months. Till those cases are completely disposed of, let the voter list be completely frozen. Let they coming back to the voter list with any possibility, that as an idea, let's not entertain it any further. To which Justice Jayamalla Bagchi very categorically stated that there is something called Article 142 that they will be exercising, that the court would be exercising, which is almost like an exception they may choose to bring if they deem that to be right. So the Supreme Court today has made one thing very, very clear, that they are not close to the idea. They're absolutely not saying a no to this idea of voters who go through the tribunal exercise, clear them out, find them as valid voter, find them ratified or validated as a valid voter once again. Should they be given a chance to come back to the voter list and allowed a chance to cast their vote this election, if this entire process happens before first phase and second phase? To which the Supreme Court is saying, let's wait and see. That's exactly what we are looking at. So yes, today was not the final hearing. The case will be coming up again this week, later this week, but today was certainly not the last day of hearing on this very matter. So those who have applied before the tribunal, those who have endured the wrath of a scorching sun and stood there the whole day to file an application and also be physically present for a hearing, they should not be disappointed completely. There is still a tinker of hope, still alive, because the Supreme Court is not saying a no to the idea of those people coming back to the voter list if their matter is cleared up by the tribunal, and that to be for elections. Before ending this broadcast, I would want to play what Justice Jayamalla Bagchi said specific to this very hearing. Listen in.
Of the registration
Yes,
of electoral roll.
yes.
An interim suspension of a decision cannot be done in appeal.
No, let us keep the
Any
intent.
other aspect,
Yeah.
55% objections have been rejected.
Yes.
Those, they have been included.
Yeah.
The objectors have gone appeal against that. The
Yes,
34
okay,
lakh
that's how you
appeal-
get 34 lakhs.
Yes, ask for the same order.
Correct.
No,
They will also ask for the same order.
Now,
but
We got back to the same position before appointment of the judicial officer.
But kindly-
Proviso, as your lordship correctly points out,
ये वाला
perhaps the proviso
फाइट होना ही
pushes the proviso, my lords, which is the statutory wisdom of the legislature, appears at least to us to revert the position prior to the SIR exercise. Please just consider that element.
No.
If that is the case, my lords, I would make two suggestions. One is your lordships will consider how to balance these appeals, particularly having regard the proviso to 21(3). And the second respectful submission that I have is that surely, my lords, if the appellate tribunals which have just started functioning, I think that was the,
Good morning.
yeah, they've just
As per the-
initiated. If there is substantial progress, my lords, over the next week, then surely there ought to be, my lords, please keep in mind. some-
That is what we are seeking to focus on.
Yes, yes. Some supplementary, my lords, list which comes out.
That we are seeking to focus.
We are also equally conscious of this.
No, I'm very grateful.
Millets,
but
when
that
it
is
comes to
point-
section 21,
Correct.
it's an ongoing process. It goes on. When it comes to millets, freezing and finalization and the right to vote in that particular one millets, that's governed by section 23, read with the rules. Insofar as 21, nobody denies it should go on. That's what my lords have held. That the appeals, let them go on so that they'll have their rights vindicated if at all they could. And then,
Mr. Naidu, we are conscious that pending of an appeal does not amount to suspension of the primary decision. Right, that is the rule under the rules. But if an appeal is disposed of, what would be its consequence is also in the rule that is subsection 5, that the registration officer will immediately amend the electoral roll.
millets subject to, millets,
So there.
Yes.
And there, Mr. Naidu, subject to our exercise of Article 142 powers.
millets, yes, millets, when, as and when your lords take up millets, we'll submit our notes, we'll submit the decisions because it has at least half a
Can I
dozen
make
times
one
considered
request
by
to
your
your lordship?
lordships.
I just want to quote as was Justice Joymal Bakshi observed verbally today. When Senior Advocate Diwan pointed out this section 21, subsection 3 of the Proviso Act, and Election Commission's appeal made through Senior Advocate Naidu clearly said that this is an ongoing process. And as and when the court decides to invoke Article 124 and decide on something, they would be registering their application and case at that point in time. It's then when Justice Joymal Bakshi said that pendency of appeal does not amount to suspension of it, which means you who have filed an application before the tribunal challenging the Election Commission's decision to delete you, if that matter is pending before the tribunal, that doesn't mean that you have been suspended as a voter. Point one. If an appeal is disposed of, which means you go to tribunal, your case is heard, and you are being disposed of. The matter is being disposed of, either positive or negative, but the matter is being disposed of. What would be the consequence? Say, suppose you are reconsidered as a valid voter by the tribunal. If tribunal finds you to be a valid voter, even after Election Commission deleting you, what happens then? Justice Joymal Bakshi says it will be the job of the electoral officer to modify the voter roll. But will that happen before Bengal election 2026? There is definitely a lot of ambiguity as yet. Because that's the clarity that people were looking for. That if I'm being cleared by the tribunal, will I be given a chance to cast my vote in Bengal election 2026 if the clearing process happens before first phase of polling? To which there is no clarity as yet. And thus we can neither say a yes or a no. The fact that we cannot directly say a no, the fact that Supreme Court also did not say a no to that idea, which means there is still some hope alive. To what extent? Not really sure. But the very fact that today's Supreme Court had reminded Election Commission of India that you did not do logical discrepancy during Bihar SIR in 2025, that you simply followed mapping of voters to decide who is a valid voter and who is not. And contrast, you did logical discrepancy to disenfranchise voters in Bengal in a couple of months' time. the fact that Election Commission of India is now facing this question coming from Supreme Court, it's itself a reckoning. It's itself a reckoning. It is a matter of concern that if there are 34 lakh cases now before the tribunal, and they're all challenging it, because they have some amount of confidence. They're not challenging it for fun. And please understand, everyone who's moving there, they're shelling out an extra cost. If hiring a lawyer is not a cost that they are incurring at this point, but filing an application means photocopying several documents that they have given Election Commission multiple times before they were finally deleted. So photocopying those documents is also an additional cost. And for you, 500 rupees might be just another expense. But for millions of rural Bengal people who survive on daily wage, who struggle every day to meet their ends meet, for them, spending 500 rupees after photocopying and after reaching to a spot to file an application or appear before a tribunal, and everything of that comes against a cost. For them, 500 rupees is also a luxury. See, if they're spending that amount of money and yet deciding to challenge Election Commission of India, which means they do have some amount of confidence inside them. And if this confidence is rooted to documents, including passport, then they probably would have a fair chance to make it through tribunal and come back to the voter list. Probably they will be casting their votes in the future too. But why will they not be allowed to cast their vote in Bengal election 2026? And why Election Commission of India is opposing that idea so vehemently is something anybody with any mind and sense would find very, very bewildering. We end our broadcast here. But the fact that the Election Commission of India has opposed to this idea time and again, I believe they have only made themselves open to more scrutiny and public questions. For now, those who have joined this broadcast, please leave your thought, leave your comment as what do you think? Should they be given a chance to cast their vote in Bengal election 2026? If their names are cleared by tribunal and before election? Leave your thought. Leave your thought. Leave your thought in the comment section. Let us also understand what is the larger public opinion. Because what we are sensing on the ground, those who have their votes secured, they are as much worried as those who have lost their voting right, being deleted by Election Commission of India. Because as great men have always said, injustice to one is a threat to justice to everyone and everywhere. Leave your thoughts, leave your feedback, leave your comments in the comment section, and do like, share, and subscribe NTT and NTT Bangla. I thank all our viewers for joining this broadcast live. We will be coming back live again very soon, very shortly. Thank you.